J.G. Zuma in another.
But please, the court, my lord, I appear for the state in this matter, together with my colleagues, Mrs. Kutsia and Mr. Matenjwa.
Excuse your lordship, I appear for Mr. Zuma, with my learned friends, Mr. Sikatani, Mr. Kubia, Mr. Masuku, and Mr. Sikatani. My lord, at the outset, may I apologize for the late start. It all had to do with the logistic nightmare of gowns left behind in error in a hotel room and the necessity to turn around. It is entirely my fault, and we're deeply sorry.
Okay. Right.
I think Mr. Dana would take up the proceedings for a moment, and then I'll have something to say with your lordship's leave.
All right, thank you.
Lord, I, with Ms. Alikari appear on behalf of accused number 2.
My lord, I think it's appropriate that I should then start proceedings in the following way. My lord, the court will remember that today is a holding date. It's a provisional date in the criminal proceedings, which were postponed to today in order to allow my learned friends for the defense to bring applications for permanent stay. Those applications have been duly brought. They are before the court. And my lord, pursuant to the applications, the parties have been in consultation with each other, negotiation about a timetable for the future conduct of this case. And my lord, I'm happy to say that we reached agreement, and we have a draft order which is before the court, and we will ask your lordship to consent to the order, to issue the order. And very briefly, might I just say that part of the order, as far as the criminal proceedings is concerned, is to postpone the criminal proceedings to the 20th of May 2019, pending the exchange of papers between the parties, which my learned friend Mr. Helens will put on record if the court so deems it. And so then I ask that the criminal proceedings be postponed to the 20th of May 2019, and for the exchange of papers leading up to the court proceedings, where there will be argument on the permanent stay on the 20th of May and in the days thereafter. My lord, from my part, could I also just put on record that the state did not require the presence of the representative for accused number 2, Mrs. Guria. Your lordship will remember that your lordship excused her last time, and we do not require her presence either on the 20th of May. So if the court is in accordance with that, we would ask that your lordship, if you look at the order by consent, the draft order, you'll see that paragraph 1 says the accused are warned. We would ask that it just be amended to the accused number 1 is warned, and that nothing further need be said about accused number 2 for the present. If that is in order, my lord, that is all I have to say for the moment.
Thank you. Yes.
From accused number 2's perspective, that's correct. Perhaps just from a grammatical point of view, my lord, you may want to add in the word, between the and accused, the word first, because the way it's currently worded is the accused, which could suggest that it's both accused number 1 and 2. The lordship may want to just add in the word the first, in accordance with the arrangement that Mr. Downer and I have entered into. And yes, and Mr. Downer has suggested, and we would concur with it, is the word are should read is, because the warning relates to only one accused rather than 2.
But you are present representing accused number 2.
Yes, no, I represent accused number 2, but the technical representative for purposes of the Criminal Procedure Act is not me. It would be an official of the company. I'm an official, I'm an advocate.
So the rumour goes.
And the other point that your lordship might want to take note of is that your lordship, if one has regard to the front page, the court will see that there are 2 cases with different case numbers. In my capacity today, or our capacity today, we are only in the first case, which is case number CCD 30/2018. And as you can see, my lord, we are the second accused. But your lordship will see the bottom of the page, or the second half of the page, is another case called D1273/2018. Now that's a civil case that our clients have launched in the Durban High Court, but by agreement with the state, and as I understand it, the imprimatur of the Judge President, both this case, the criminal case, and the civil case will both be heard on the 20th of May, 2019.
Okay. So, while you are on the fleet, you remember on the last occasion there was an argument about the existence or otherwise of Section 5B.
Yes.
And the state undertook to amend that. Has that amendment been effected?
No, my lord, what my attorney reminds me last night, this features in Mr. Zuma's papers, which he wasn't aware of, but what happened was the state undertook to revert to us as to what they were going to do as far as the indictment is concerned. And they reverted to us within the time period, I think it was within the time period, and they suggested that they weren't going to amend the indictment, and the indictment stands as it was when they presented the indictment to us in the first part of the year. I think it was in March this year. So that wrong reference by the former NDPP, Mr. Abrams, has effectively just, for all intents and purposes, fallen away. The reference to a section that doesn't exist. It's become a dead letter contract. But Mr. Downer can perhaps, he's better able to, from our side, we make no claim. It's not in our
But are you satisfied? Because I've seen in the papers of accused number one, who's now the applicant in this in the application.
What we suspect must have happened was that the state responded to us, but not to Mr. Zuma. That's all we can suspect happened. But from our side, we satisfied. But I can understand from Mr. Zuma's side why he might have a, let's call it a complaint about what actually happened. But we
don't have a complaint. You don't have a complaint.
We've got no complaint about that now. No, not really. But I could, whether Mr. Zuma's got one or not, that's his play.
But that's quite strange because previously you had a complaint. So now I don't know what happened to the complaint.
Before you had a complaint, now you don't.
Well, what happened was we made representations to Mr. Abrams, the Lordship before, and he rejected them. But in rejecting them, he did a few things. He rejected them in our submission for unusual and for our submission wrong reasons. Leave that aside. He also then said he's told the prosecuting team, that's Mr. Downer's team, to consider adding charges to the indictment. And he mentioned a section of an act which didn't exist.
Yes.
And Mr. Downer on the previous occasion reflected that my submission that the section didn't exist was correct. And then your lordship put Mr. Downer to terms, the prosecuting team to terms, to revert back to us as to what they were going to do with Mr. Abrams' suggestion. And I can't remember exactly, but they did come back to us within the time period stipulated by your lordship to indicate that they weren't proceeding with those non-existent charges, if I may put it that way, or charges based on a non-existent section. So they're not proceeding with those extra charges. We don't understand how it ever came about that happened, but we've got nothing to say about that. I know Mr. Zuma says something about it in his papers. Obviously, he's not privy to, he couldn't be privy to what that was about.
Okay.
I'm no comment. We have no comment about that at all.
All right. Thank you.
My Lord, could I then just confirm that from the state side, my learned friend for accused number 2 is correct. We were put on terms. We did immediately deal with it. We informed accused number 2 that that issue is no longer an issue. The indictment was never meant to be amended. It wasn't amended, and that issue was put aside. If indeed we should have informed accused number 1 as well, we were under the impression that that was an issue between accused number 2 and the state, and not accused number 1. I apologize if accused number 1 thought he should have been informed. It didn't involve him, and that is a non-issue because the indictment was not amended, and accused number 2 was so informed. So we complied, and it's now, I would submit, a non-issue, certainly between accused number 2 and the state.
Lord, if I could deal with that topic very briefly, this is not the time to argue the permanent stay, nor do I intend to do so. But it is raised in our permanent stay papers because we were never informed that the indictment would not be amended. From our point of view, the indictment remained, the query about the amendment to the indictment remained unanswered. And it is not so that Mr. Zuma is not affected by that indictment, because evidence, if the indictment were amended, would be led in the trial. And as you know, any evidence led in a trial is admissible against all the accused. It may have been that the charge was leveled at accused number 2, but the evidence and the surrounding miasma in context would have had an effect on my client, on our client, and we would have needed to have known that the indictment was not or was amended. A criminal trial doesn't happen in compartmentalized compartments. And we say in the permanent stay application, we will argue that this is another indication of the dismissive attitude demonstrated by the NPA to our client in the broader context of the case we made out for a permanent stay. But my Lord, that is all I have to say for the time being. When we argue the permanent stay, I will be much more voluble on that topic. It is indeed quite serious. But if I could turn your Lordship to the draft order, your Lordship's attention to the draft order, it is indeed so that we have an agreement on all fronts with regard to the postponement and the terms of the postponement. It is so that the matters the permanent stay application is to be dealt with on the 20th of May and the following 3 consecutive days in this court. Then if I could explain the mechanics of the balance of the order which we asked your Lordship to make. And by way of explanation, paragraph 2 sets out exactly what I have said. Paragraph 3.1, you may want to know what that means. It says the state shall supply to the first accused such documents as it is going to supply by 7 January 2019. Insofar as your Lordship is asked to make an order to that effect, you should know the background, and I'll explain it extremely briefly without trying to cast any blame on anyone. Prior to the hearing on the 27th of July, we addressed a letter to the state asking for a series of documents relevant to the issue of permanent stay. After a number of reminder letters, where each one was met by silence or our client is thinking about it type responses, we were told that they were not going to give us anything. And if we wanted documents from the state, is the recording still running, Wallo? Says, if we wanted documents from the state, we must apply. That is 2 months after we wrote, where we had a now shorter period to design our permanent stay application. So our response was, this is a further frustration of Mr. Zuma's rights, unjustifiably, and we filed a permanent stay application in which we explain why we were entitled to these documents and why the not giving of the documents was I'll be as brief as possible. The client is unwell. Why the not giving up the documents was a game of catch me if you can. So against that background, it's been agreed that the state are now thinking about giving us documents or thinking about not giving us documents, and that decision will be made and implemented by the 7th of January. Thereafter, to rush through it, the rest of the paragraphs set out a timetable for answering papers, replying papers, and the matter, and heads of argument, and the matter to be ready to be argued on the 20th. Subject to nothing more, that is what I have to say.
Okay. Well, I don't think there's anything more to raise.
My Lord, just one more thing. It's something for the Judge President and yourself or whoever else is responsible. There's been a suggestion that the permanent stay might be heard by a full bench. And we would raise a small query about that, which gets even larger when you think about it, and that is the permanent stay is a matter for the trial court, in our view, and a trial court in a criminal case is one judge. We wouldn't like some irregularity to be given effect to by 3 judges hearing one part of what is one criminal trial. But your Lordship doesn't have to decide that. That's a matter for yourself and the Judge President in your more administrative capacities. But we would just fire a signal flare of danger of irregularity if that course is followed. As the court please.
Okay. So, Mr. Downer, are you also of the same mind?
On that point, no, my Lord, no. We're subject to the Judge President's direction, and that is a matter which can be sorted out if necessary in future.
Okay. As we are in the open court, I have to read the order for everybody to understand, or to hear and understand what is going on and what will go on again. By agreement between the parties, the following order is made. 1. The criminal proceedings in case number CCD 30 of 2018 are postponed to 20 May 2019, and accused number 1 is warned to appear in this court at 9:30 on that day. 2. The application brought on 15 November 2018 by Thales South Africa Pty Ltd under case number D12763 of 2018 shall be held in this court from the 20th to the 23rd of May 2019, together with the application brought on 16 November 2018 by the first accused in case number CCD 30 of 2018, Mr. Zuma, for an order that the charges set out in the indictment be permanently stayed and further relief. 3. Both applications shall be governed by the following timetable. 3.1. The state shall supply to the first accused such documents as it is going to supply by 7 January 2019. 3.2. Mr. Zuma shall supplement his founding papers by 7 February 2019. 3.3. The state, a term which henceforth in this order includes the respondents in case number 312763 of 2018, shall deliver its answering papers in both applications by 1st March 2019. Mr. Zuma and Thales shall deliver their replying papers by 1st April 2019. Mr. Zuma and Thales shall deliver their heads of argument by 18 April 2019. The state shall deliver its heads of argument in both applications by 10 May 2019. That is the order. And Ngamalala, you want to appear before this court on the 20th of May. And you'll be on your own recognizance. If I'm correct, it's not on bail. You'll be on your own recognizance until that day. The order is granted.
That's all wrong.
Okay, thank you. Court adjourns.